Hello, everybody, and welcome to this CPD session presented by Ian Rennie on passwords and encryption. I'm Glenn Tate from the Law Society. I'll be moderating the session this afternoon. A couple of points as we go forward before I turn it over to Ian. First, if you have any questions, please use the chat function in Zoom, and I will then take the questions and bring them forward to Ian. Second of all, we are recording this session and we will be putting it up on the Law Society YouTube channel shortly after the session is over. I'm very pleased to introduce Ian, who is known to many, if not all of you. Ian is a lawyer with the GNWT Department of Justice, and he has I think it's fair to say a diverse and eclectic interest in many things, one of which is passwords and encryption. And with that, I'm going to turn it over to Ian. Ian, over to you.
Thank you, Glenn. Thank you, everybody. Welcome to Passwords and Encryption, a legal maelstrom, and there be sea monsters here. Nothing in this presentation should be construed as representing any official statement or opinion of law by me, the presenter, the Law Society of Northwest Territories, or the Government of the Northwest Territories. So that's just a little caveat to start off with. The CPD goals in this CPD presentation are to reflect some substantive law, procedural law. There is an aspect of professional ethics in this presentation, some practice management issues, and lawyering skills. So all of these are addressed in this CPD. The objective of the CPD is to present an overview of what passwords and encryption are, to alert you as to their existence and how they are dealt with in law, to sensitize you with some of the ethical issues that surround these, and to alert you to the risks of unnecessary disclosure or failure to disclose when so required. Here's a list of the sources, but by no means is it complete. There's the Northwest Territories Code of Conduct from 2015, and the CBA Information Supplement to the Code of Conduct, guidelines for practicing ethically with new information technologies. There are some cases of interest. Dhindsa, which is just a Law Society of VC case. The Crown against Fearon, which some of you, particularly the criminal practitioners, are probably well acquainted with, and the supporting case law. There are various sources online, for example, how to encrypt with passwords, Microsoft files and Adobe PDF files, for example. So this is the outline of the presentation. It's basically divided into two segments. First one deals with passwords. We'll explore what they are, how they should be selected. Then we'll have a look at the Crown against Fearon, which is kind of interesting. And that brings up the whole issue of searches incidental to arrest. In that case, it was a cell phone with no password protection. The second part will deal with encryption. So we'll distinguish between codes and ciphers, the necessity to make use of encryption, statutory requirements, professional aspects. We'll have a look at McLean versus the Law Society of BC, which raises some interesting ethical issues. And then we'll have a quick look at some of the provisions in the Code of Conduct. Time permitting, we'll have a look at the Snowden Affair and some of the other things which have been developing on this subject. And then we'll also do a word exercise, basically how to encrypt a document. So, passwords. What is a password? I'm sure everybody's familiar with the concept of a password. It's a user, there's two components to it. There's the user ID and the password or login. The most basic form of security, you see it in laptops, modern laptops, and in Windows. Older versions of Windows did not have it. Cell phones, tablets, and PDAs, which nobody uses anymore, personal data assistance. Passwords typically are composed of numbers, letters, and symbols. They're of minimum length. And if you have a look at the alphabet, there are 26 letters in the alphabet, and there are 10 numerals, 0 to 9 in terms of numerical figures. If one looks at the characters on a keyboard, computer keyboard, typically the ASCII character set, there's 128 characters, and so forth. So if you use anything on the keyboard, including characters like the caret or the percent or dollar symbol, you will find that the number of combinations can be 128 characters times 128 times 128 times 128, possibly repeating. As you see, there's 128 to the power 9 possible combinations. The more characters in your password, the harder it is to use methods to break it. So here you can see the exponential aspect of it. Just a quick graph, and you can see 128 to the power of n is the green line, and it's much steeper, a much steeper exponential curve than the alphabet. The choice of password, that is a word, reduces the base from 26 to 128 and creates a significant vulnerability in that the word is present in a dictionary. If one chooses something like a birth date or a proper name, that is even worse because these things are very specific. So this is also giving an indication of how hackers might hack your password. A single password for everything may be easy to remember, but the consequences of disclosure could be severe. If you write the password down or record it, is that record now a vulnerability in itself? So just some things to think about. I do remember the bank telling me that I should have a single password for everything. I didn't follow their instructions. The worst passwords: the name of a pet, child, family member, or a significant other, anniversary dates or birthdays, a birthplace, name of a favorite holiday, something related to a favorite sports team, or the word password, or even worse, default. Now, some of you may actually do online financial matters. For example, the CRA website, My Account. And these typically are security questions, but they're not part of your password profile. There is software that can carry out brute force attack methods, so all possible combinations. I'm sure many of you have briefcases with combination locks, and typically there might be three numbers on that combination lock, 0 to 9 in each of them, and it is possible to dial the combinations and to eventually get the right combination and open up the lock. That would be a physical brute force attack method. But software, computers do that very well and a lot quicker than manually. Some people leave passwords in their wills. This is a huge issue in respect of probate for online assets. ULCC, which is Uniform Law Conference of Canada, and the American counterpart, the Uniform Law Conference, are working on this with some model legislation. You can also end up with deceptive emails called phishing. Your account, typically they would say something like, your account is about to expire, send us your login and password details. And you can see immediately when you look at these email addresses, they're immediately cause for concern because they're suspicious. So in terms of the Microsoft one there, you can see that it's missing an I. And the Hotmail account is a dead giveaway as well. Phishing is the practice of creating mirror websites. They take it even further than just an email. They put in a hyperlink to take you to their website. So creating mirror websites and then sending emails to the customer to ask them to update their records at a fake link, resulting in the customer providing personal information. Phishing sites are often extremely sophisticated and difficult to distinguish from real sites. And lately, I have to admire some of them because they do look more and more authentic. Farming is another common term. Farming involves the malicious tampering with the domain name, with the result that a customer or potential customer can type in a URL and be redirected to a compromised site without knowledge of the change. So that example of Microsoft missing the I might be an example of farming. Malware is short for malicious software and describes software that causes damage to a single computer, server, or computer network through a variety of means. Spyware is software that often obtains information from a user's computer without the person's consent. And I've got a case here. The way to deal with all of these, of course, is to have up-to-date virus protection. Now, in terms of the substantive law component, I wanted to talk about the Crown versus Fearon. Search is incidental to arrest. And there's a few other cases, so I'm not going to go into. So here, this third one is a criminal case involving BlackBerries. We will discuss McLean and Dhindsa. Briefly discuss the breach of the World Anti-Doping Database, and then the Crown versus Otto, which is Ontario Supreme Court. So in Fearon, it was an armed jewelry robbery. Police find the vehicle and arrest F and C. During a pat-down search of F, conducted incidental to arrest, police find a cell phone in F's pocket. Police searched the phone at that time and again 2 hours after the arrest. They find a draft text message. We did it. I think it should be where the jewelry at Nigabur photos, and there were also photos including of a handgun. A couple of days after, the same handgun, of which there was a picture, was recovered from the vehicle. 1 month later, police were granted a warrant to search the contents of the phone. No new evidence was discovered. So is this a breach of Section 8 of the Charter? A reminder of what Section 8 of the Charter says: everyone has the right to be secure against unreasonable search and seizure. And the majority ruled that it did not breach Section 8 of the Charter, but there was a significant dissenting contingent in the judges. So it was a 5-4 decision, which isn't particularly strong. The majority, the common law power to search incidental to lawful arrest, permits the search of his cell phones and similar devices found on the suspect, although some modification of the existing common law framework is necessary because the search of a cell phone has the potential to be much more significant invasion of privacy than the typical search incidental to arrest. The power to search incidental to arrest is extraordinary in that it permits reasonable searches when the police have neither a warrant nor reasonable or probable grounds. That the exercise of this extraordinary power has been considered in general to meet constitutional muster reflects the important law enforcement objectives which are served by searches of people who have been lawfully arrested. This power must be exercised in the pursuit of a valid purpose related to the proper administration of justice, and the search must be truly incidental to the arrest. There are some conditions, and I was looking at a website on the Department of Justice. Some of you might know it. I think it's sort of a encyclopedia of the charter, of charter cases, and they reiterate this majority, these majority aspects. So first, the arrest must be lawful. The search must be truly incidental to arrest. The nature and extent of the search must be tailored to its purpose, not a fishing expedition. Finally, the police must take detailed notes of what they have examined on the device and how they examined it. In this case, the initial search of the cell phone, which disclosed all the cell phone evidence tendered by the Crown at trial, breached F's Section 8 rights. Although they were truly incidental to F's arrest for robbery, they were for valid law enforcement objectives and were appropriate linked to the offense for which F had been lawfully arrested. Detailed evidence about what precisely was searched, how and why was lacking. Despite that breach, the evidence should not be excluded. And there's some rationale there in the slide. The dissenting judges are interesting to have a look at. Remember, there's 4 out of the 9 dissented, and they were of the view that searches of personal digital devices, including personal computers, risk serious encroachments on privacy and are therefore not authorized under the common law power to search incidental to arrest. Only judicial pre-authorization can provide the effective and impartial balancing of the state's law enforcement objectives with the intensely personal and uniquely pervasive privacy interests in our digital devices. Generally, law enforcement interests will outweigh the privacy interest that an arrested person has in the physical items in his immediate vicinity. However, the privacy interest in a digital device is quantitatively and qualitatively different from that of other physical items and traditionally subject to such searches. Why? Because they have an awful lot more information. The cell phone cannot be treated like any other piece of physical evidence that may be found on the arrestee and search incidental to arrest. Individuals have a high expectation of privacy in their digital devices because they store immense amounts of information. Our fastidious record keepers retain files and data even after the users think they have been destroyed, make the temporal and territorial limitations on the search incident to arrest meaningless, and can continue to generate evidence even after they have been seized. So I won't go through the rest of this. These are extracts from the case, and particularly from the dissenting judges. Just to remind, in this case, in order to access the photographs and the text message in the cell phone, the investigator had to operate the keyboard on the phone. The cell phone was turned on, and there was no evidence that it was password protected or otherwise locked to users other than the appellant. The photographs and the text message were not in plain view, and it was necessary to manipulate the keypad in order to move the phone into its different modes. I think many people have concluded from this that without the password, it was fair game. If there was password protection, then that would have been a different matter. Interestingly, the police carried out an examination of the contents of the phone without a search warrant. Many months later, police hear of a court case and apply for the search warrant. I was curious because Fearon dates from 2014, and I just wanted to see if there was any update. And I had a quick look on Canley, and it looks like the cases are still generally supportive of the Fearon case. So the Crown versus Gibson, it's a BC provincial court case, so it's of low court authority, but it has a very good discussion. And I think there are some provincial court of appeal cases, so I just put the Alberta one here, Crown versus Cranfield, but I think there's also an Ontario one in the Canley report. What role does a password serve? There are some other cases of interest. Here's a Supreme Court case of Canada, SCR. Password was not a personal password. It was available to the administrator only. The evidence was excluded because of the limitations on search incidental to arrest. In these cases, it would likely have rendered the CETA less effective and precluded a warrantless search. I do remember when I presented this many years ago, there was a question about fingerprints as passwords. An iPhone 5S, which is probably now completely obsolete, I would imagine, had a fingerprint reader. Can a fingerprint be a password? What if it's disclosed? So that was a question by Senator Al Franken in September of 2013. Something to think about. I think a fingerprint is a very poor password. Why? Because it's unique to the person. All that one needs to do is somehow capture an image of the fingerprint, and then you can hack. Laptop startups, it is possible to encrypt hard drives the consequence of loss, backups, mitigation. Example of password protecting a document. Here is a hyperlink, which shows you how to do it. And time permitting, well, I'll show you right now. We can actually give you an example of how to do it. So this is my Word document. Can everybody see that, I hope? Yeah. So this is my example of a Word document with a very sensitive text. And this version of Word is Word 2020. So I was a bit thrown off when I looked at this because I don't use that version of Word. But in previous versions, it was the properties that you would look for, and then you have the option to password protect the document. In this version of Word, I go to Info. There it is, Protect Document. Encrypt with a password. And I type in my password. Now, what does that do? What it does is it's not really password protecting. It's actually full and proper encryption. In older versions of Microsoft Word and Office, 2007 and before, it used 128-bit encryption to the AES standard, which is it's a commercial standard. Office 2016 and above uses a much better one, which is 256-bit. Office 97 to 2003 uses only a 40-bit key, RC4, which is considered to be very insecure. So if you want really good password protection in your Word software, you probably should update it if it's still in the realm of Office 97 in 2003. LibreOffice, which is an open source word processor, it has 256 AES standard. Adobe Acrobat 6 to 9 has a 128-bit standard, although the early versions have RC4. X plus, so anything greater than Acrobat 10 has 256 bits of AES. So that is actually commercial banking standard. Dhindsa. So this is a Law Society of BC case, and it is available on Canly. Basically, the lawyer was disclosing his JuraCert password to his staff and permitting them to affix his electronic signature to documents filed with the Land Title Office, contrary to the Law Society rules and also the BC Code of Professional Conduct. JuraCert, in case you don't know what that is, that's an electronic filing system which the Land Title Office in BC has adopted, and it's quite active. JuraCert does not exist in the Northwest Territories at this time. This case has implications for electronic court filings if you have access to that. We don't have access to that in the Northwest Territories court system yet, but it is possible in the other jurisdictions and also in federal. It also has applications to other administrative e-filings, such as the US Patent and Trademark Office, extra jurisdictional courts like BC, Ontario, and Alberta, and the Law Society of the Northwest Territories. I'm not quite sure what the state of our electronic filing system is in. Glenn, did you have some idea of that?
Sadly, Ian, I don't. Sorry.
Okay. I know it's a direction which everybody is moving towards. The BC Code provides at section 6.1-5, a lawyer who has personalized encrypted electronic access to any system for the electronic submission of or registration of documents must not permit others, including a non-lawyer employee, to use such access or disclose his or her password or access phrase or number to others. This is identical in the Law Society of Northwest Territories Code of Conduct. And here's the extract from our Code of Conduct. By the way, this is an ethical component. And you can see that it's pretty well verbatim. I wanted to mention that there have been recent changes to the Evidence Act, the Federal Evidence Act, and even more recent changes to the Evidence Act of the Northwest Territories with respect to electronic evidence. The sharing of these passwords and the like tends to screw up the reliability of the electronic evidence and its chain. So there is actually a logic behind this and a compelling reason. The commentary of the Northwest Territories Code of Conduct. The implementation of systems for the electronic registration of documents imposes special responsibilities on lawyers and others using the system. So you can see that that's very general. It doesn't make reference to the changes in the Evidence Act because those changes probably predate or postdate the issuance of the Code of Conduct. In real estate practice, when it is permissible for a lawyer to delegate responsibilities to a non-lawyer who has such access, the lawyer should ensure that the non-lawyer maintains and understands the importance of maintaining the security of the system. In a lot of these electronic filing systems, it is a term and condition that the person who is registered does not share the password with a third party. And it could be cause for them to have their account suspended. So I wouldn't just rely on the Code of Conduct. You should also have a look at the user agreement with the provider. Returning to Dhindsa, so it was found on the bounds of probabilities to be guilty of professional misconduct. Broad implications, as I have mentioned, generally with respect to e-filings. The breach of the World Anti-Doping Database, so that was 2018, was kind of interesting. It was a phishing attack on their system. Disclosure of athletes' personal information, including health information. Fancy Bear, I think, was the alias for whoever was doing it. The accounts, the controls, and the passwords and encryption were all compromised. I think we know it may have been done by the Russians. In the case of Otto, the criminal case, trafficking in fentanyl, failure to obtain assistance to get the password. It's a valid warrant. Police obtained the password from the software provider. Password used for limited purpose, properly obtained. It's okay. Charter rights give way to interests of the administration of justice. So the evidence was admissible in that particular case. I was trying to figure out why I'd put this picture in, and I think it's because Otto is the name of the Kevin Kline character in this movie. And since it deals with lawyers, I'm sure that some of the lawyers out there have seen it. John Cleese, of course, is trained as a lawyer. Encryption. What is encryption? Encryption is a way to enhance the security of a message or file by scrambling the contents so that it can be read only by someone who has the right encryption key to unscramble it. For example, if you purchase something from a website, the information for the transaction is usually encrypted to help keep it safe. Use encryption when you want a strong level of protection for your information. Now, I have a hyperlink here to Windows 7. And of course, Windows 7 is not current. We're at Windows 10 these days, but I haven't updated that. History of encryption. The difference between codes and ciphers. A code, one word maps onto a full message. For example, the word accountant could actually mean, come at once, do not delay. And you need a code book that goes with that. It's a very, very poor system of hiding information, and it can easily be broken. A cipher is a mechanical operation or algorithm. So when you hear the word algorithm, you should think of math that takes letters and shifts them. shared key to encrypt and decrypt. 19th and 20th centuries, statistical and frequency analysis started to be applied to codes and ciphers, resulting in the mathematical foundations of computers. It's Alan Turing, the ability to decode, the development of the Enigma machine, which is the Germans in World War II, Colossus, which was the first computer developed by Turing to break those codes, and then the rise of the computer. And then a special area is the development of cryptography. And there is an aspect of this to the game Scrabble. So here's a picture of Alan Turing. I believe this might be an Enigma machine. Bletchley Park is where it all happened. I think this might be an image of Colossus here, the first computer. So here's the process in a flowchart. The message in plain text, it's encrypted using the shared encryption key, becomes ciphertext, which is impossible to, or very difficult to break. And then it's transmitted, it's received. I think rather than reception again, that should actually be ciphertext. Then it's decrypted, and then it's turned back into the message or plain text. This is an example of frequency distribution of letters in the alphabet. And the rightmost histogram is in order of the frequency. So if you have if you want to try and break a code or a cipher, you can actually start applying statistical techniques, because you know that E is the most common letter used. So in the Scrabble game, it was developed in 1949 after the fundamentals of cryptography were figured out. It's after World War II. Frequency analysis can be used to predict the likelihood of letters. So if you see this little circled thing down underneath the word Scrabble, it's a tile inventory. How many tiles of each letter exist in the game, and if you stack them together, you actually end up with a histogram of frequency of these letters. So it's all there for you. It's based on the New York Times crossword rather than the dictionary. So it's kind of interesting. So again, with encryption, it's a means of controlling dissemination of information, protecting information from inadvertent or unauthorized disclosure, and it is a process or algorithm. Is it necessary? Well, the first thing when one considers this is, what is the level of risk? Just how sensitive is the information you have? Are people seeking out that information, and what are the consequences of disclosure, both to your client and to you? Cost of encryption? Well, today it's quite negligible because the cost of computers has really dropped, but it wasn't always. I mean, Colossus was a very expensive computer to develop. What level of protection? Maybe just a sealed envelope or a double sealed envelope would suffice. Is password protection enough? So that's the commercial AES banking standard, 256-bit. Are you dealing with state secrets? Is your client an alleged terrorist or criminal mastermind? In that case, maybe AES standard isn't sufficient, in which case there is another standard of encryption called PGP, pretty good privacy, which is even stronger. So again, the client risks and the professional risks. So again, there's an old form of encryption called DES encryption, not considered to be very secure anymore. AES encryption, we already talked about 256-bit seems to be the standard at the moment. And then there's a PGP encryption. So here's a quick outlook on AES encryption. There are compression programs, for example, WinZip, that uses a password as the encryption key, and that password is also the decryption key. And it does do this to 256-bit AES standard. So that's banking standard. 7-zip is actually free and open source, and it also does AES 256. And there's additional features in 7-zip. It actually uses big number of iterations to produce a cipher key from the text password. As IT develops, so does the ability to break these. Communications Security Establishment Canada and the Government of Canada use these types of encryption methods with modules. The TD Bank Financial Group uses 128-bit encryption, but not all web browsers do. I'm not sure that's current anymore. I should really update that. I think they probably use 256-bit. At the time I prepared these slides, Internet Explorer seemed to be current, version 8. It's now version 10, I think. You can actually look into the program in the help about menu options to check out the cipher strength. Older browsers use 40-bit encryption, which is very, very poor. In this example, we have an Internet Explorer. It's using 256-bit. By default, it's turned off. I don't have an answer why that is. I don't even know if that's still current. Chrome also has encryption capabilities as well. Internet Explorer is becoming defunct, and MS Edge is replacing it. And there are security vulnerabilities in the latest versions of Internet Explorer, and it's actually being phased out by Microsoft. They are decreasing their support to it. This is a graph up to 2015, and you can see the use of web browsers, and Internet Explorer is that blue line that's on steep decline. And you can see that Chrome is actually in ascendancy, followed by mobile versus desktop. I think that's the phones. Statutory requirements. So there is something called Personal Information Protection and Electronic Documents Act. That's PIDA, which some of you may have heard of. They adopted a CSA standard regarding protection of personal information collected by an organization, association, partnership, person, or trade union. I would expect that that would probably apply to the Law Society. Is that right, Glenn?
I believe so, Ian, yes.
Methods of protection should include physical measures, for example, locked filing cabinets and restricted access to offices. Organizational measures, for example, security clearances and limiting access on a need-to-know basis. Technological measures, for example, use of passwords and encryption. So there you are, passwords and encryption. The Ontario Disability Support Program Act is another example. The director shall ensure that biometric information collected under this act is encrypted forthwith after collection, that the original biometric information is destroyed after encryption, and that the encrypted biometric information is stored or transmitted only in encrypted form and destroyed in the prescribed manner. So that's kind of interesting because it's also looking at the life cycle of the information. The Evidence Act from Ontario, similar provisions in BC and Alberta, and I think now also in the Northwest Territories and also in the Federal Evidence Act. The integrity of an electronic record may be proved by evidence of the integrity of the electronic records system by or in which the data was recorded or stored, or by evidence that reliable encryption techniques were used to support the integrity of the electronic record. Yeah. So, in the Northwest Territories, you might find some reference to encryption in the health information regulations. The administrative, technical, and physical safeguards required under Section 85 of the Act must include C, the use of authentication and encryption to protect information stored electronically. F, measures to protect personal health information stored and transported on removable media. How do you protect that? You have a password for accessing your removable media. For those of you who work with the GMWT, you probably know that that is actually a directive with respect to removable media. Canley 2, I did a quick search of password for Northwest Territories and encrypt because I just wanted to see how things were developing. and that's hard to see. We can have a look at it afterwards, but it's very interesting. All of these are like NTIPC, NTIPC, NTIPC. Does anybody know what NTIPC stands for?
That would be the Information and Privacy Commissioner.
That's right, and of course it's right there. So they seem to be the predominant types of cases. There were a couple in this listing. You can see there were 24, and I've only selected the first 3 that were from the Supreme Court, but they didn't actually relate in any great detail to passwords and encryption. So I posed a couple of questions here. Is the common law in this area not well developed in the Northwest Territories? Is email an appropriate form of communication for solicitor-client communications? I had a previous slide. There is a case that relates to that. Professional aspects. If we're talking about encryption, obviously the obvious one is online trust accounts, any online transaction, access to databases and control of databases, access to your financial accounting software. Failure to upgrade may mean that your online transactions are not secure and could be hacked. And there's a whole issue of crossing the border with electronic devices, both going to the States and coming back into Canada. PGP, I had mentioned, as another form of encryption, pretty good privacy. It's an open standard. It's very mathematical. Some people think that the government can't actually break it. Other people think that the government can. People who use PGP tend to be the less favored characters of society, so organized crime or even terrorists. Should lawyers use it? If they're representing a terrorist, they probably should. And I'll explain that when you see some of the other cases. So here you can see how it's considered to be quite a good method of protection. So here's an example of the Red Brigade, which was a terrorist group. 2003, an incident where they were, the police seized their PDAs, and neither the Italian police nor the FBI could decrypt the PGP encrypted files. A more recent incident regarding Boucher involved US custom agents who seized a laptop PC that allegedly contained child pornography. And the agencies said that it was nearly impossible to access the PGP encrypted files. Nearly impossible is an interesting term. That suggests to me that they did actually access it. Additionally, the magistrate judge ruling on this case in November 2007 has stated that forcing the suspect to reveal his PGP passphrase would violate his Fifth Amendment rights. So that's American law. Not to incriminate. So I believe we have that in our law as well. So kind of interesting. It also smacks a little bit of the Fearon case, except in that case they didn't have a password. Evidence suggests that as of 2007, British police investigators were unable to break PGP. So instead, they resorted to using RIPA legislation, which is the Regulatory Investigation. It's basically a statute. I have it later on in this presentation, what RIPA stands for. It allows very broad authority of the police to carry out investigations. And that they have the ability to demand passwords and keys. In November 2009, a British citizen was convicted under RIPA legislation and jailed for 9 months for refusing to provide police investigators with encryption keys to the PGP encrypted files. So it's interesting. There may be consequences of using PGP and not providing the passwords or the keys. Is Canadian law heading towards RIPA legislation? I don't know. Some Canadian case law. So we got the Crown and Beauchamp. Requirement for the Crown disclosure of encrypted files that it cannot decrypt. And there was an analog to possession of a safe that cannot be opened. Eastern School District. Failure to provide levels of protection on laptops of personal information. Passwords alone are not sufficient. University of Victoria, another IPC case. Passwords with less than 8 characters are insufficient. Here's a British Columbia health case. Failure to encrypt, so the ministry failed to protect the personal information. Ethical issues. So McLean in British Columbia, it's a good law society case. So what came into question was Rule 4-43. When an order is made under Sub-Rule 1, so this is the chair of the discipline committee, has reasonable grounds to believe that there's a discipline violation. The chair may order the investigation be made of the books, records, etc., of lawyer or former lawyer, including the electronic records. When an order is made under Sub-Rule 1, the lawyer or former lawyer must assist the persons designated under paragraph A, so that's executive director and other people designated in the investigation, to access in a comprehensible form records in the lawyer's possession or control that may contain information related to the lawyer's practice by providing all information necessary for that purpose, including but not limited to passwords and encryption keys. So we as lawyers may actually have an obligation to, at least in BC, have an obligation to provide those two aspects of information to the discipline chair and their investigating team. Legal Profession Act of the Northwest Territories, I think is probably the analog of this. 24.1, a respondent shall, in receiving notice of an investigation, produce for the inspection of the investigator all materials in the possession or under the control of the respondent that are relevant to the investigation. An investigator may require a member, student at law, or complainant to answer questions or produce for the inspection of the investigator any materials not produced under subsection 1 that the investigator considers relevant to the investigation, and the member, student at law, or complainant shall answer the questions or produce the materials. And there is an option to challenge that by applying to the Supreme Court. Or sorry, if the person being investigated fails to comply with the requirements, the investigator can apply to the Supreme Court for an order to compel the person to produce those materials. McLean, Law Society of BC wanted to access the respondent's personal cell phone in order to conduct a search, but that was not authorized under the rules. The Law Society needs a warrant for personal phone at residence, but not for the phone at his law office. But Law Society of BC can apply under a similar provision in the BC Legal Profession Act, Section 37. So you can see that it's a little bit similar, a little bit different. And in the Northwest Territories, there's also Section 24.1 and 24.2. I think I just mentioned 24.1. What happens if a lawyer or other person refused to disclose a password or ciphertext in the Northwest Territories in the course of a disciplinary investigation under the Legal Profession Act? So I think the answer is the investigator would apply to the Supreme Court under those provisions in the Legal Profession Act. There is an aspect of this in the Law Society of the Northwest Territory Code of Professional Conduct. But remember, the statutory provisions are, okay, so the 2015 Code of Conduct supersedes the previous Code of Conduct and the CBA Code of Conduct. There are some various aspects, Part 3 and Part 5. Part 5 is probably the more interesting one because it talks about the relationship to the administration of justice. So I think there would be a good case here that if the PGP is being used to encrypt materials for the purpose of concealment, destruction, or alteration of incriminating physical evidence, then that's a problem. Keep in mind that opening or copying an electronic document may alter it. You may have encountered this when you're using databases, for example, Access. Every time you open it, the entire Access database file has a different timestamp on it, the current time, even if you don't make any changes. So there are some other aspects, for example, Part 7. I don't think encryption is a sharp practice, but the consequences of an inadvertent communication could be, and perhaps even not safeguarding evidence appropriately, or even communications. I have here a CBA document on dealing with new information technologies, and you can see where these the subject matter is kind of interesting. Practice competence, confidentiality, encryption is its own category, electronic storage, and security. I have another presentation that I give periodically on metadata. Law Society guidelines. Lawyers should use encryption when the information is extraordinarily sensitive. So if you are representing a alleged terrorist, perhaps it should be, the information should be encrypted. However, developments in both technology and law support the use of encryption to protect all confidential information. And keep in mind the vulnerable devices. Encryption best practices. Use encryption to protect confidential information that is transmitted electronically, emails. Implement computer access restrictions. And use full disk encryption for any mobile computing device. So lawyering skills. I've already gone through the encrypting of a Word document, so we don't need to do this. The Snowden Affair. Edward Snowden was a former NSA contractor. He leaked classified information in 2013, including PRISM, which was a program for the tracking of emails, internet activity, and phone records. UK Investigatory Powers Tribunal looked at this in 2014. MI5, MI6, and GCHQ, that's equivalent of CSEC, Communications Establishment in Canada, disclosed routine interception of legally privileged documents. Past practice to delete such information immediately, yet in 2 cases, they claim that MI6 CIA rendition resulted from that information that was intercepted, and they were sent to Libya to be tortured. So the lawyers for the UK government admitted at the tribunal one unidentified case where potential for tainting was identified. The tribunal was not convinced there was any legality here. The REPA type legislation might have been at issue. The Regulation of Investigative Powers Act 2000, that's British legislation. There was a Canadian version of that called Bill C-51. So one of the questions that arises are the protections and policies sufficient to safeguard the administration of justice given these types of legislation. Current moves by the UK to water down the European Convention on Human Rights and also to deviate from European Union privacy directives post-Brexit suggests that this RIPA type legislation is actually ascending again. Some of you might have heard of the Patriot Act in the United States. This is just a first page of an article by Jennifer Stoddart in 2004, so quite old. And I thought the second paragraph was quite interesting. Concerns, basically with the US Patriot Act, they are allowed to seize and look at portable electronic devices and get the contents, including contents that might be legally privileged. So in summary, we had a look at passwords, we had a look at encryption, We briefly discussed the Snowden Affair, and we also did an exercise looking at Word, how to encrypt a document. Questions for thought. Is there any legal communication that is secure? Has the distinction between security, intelligence, national security, and terrorism and crime become blurred? Is there a professional responsibility to update one's software? If we are aware of NSA, Microsoft, etc., hacking email accounts, what should be done about this to act in a professional manner and safeguard our duty to the public and to the rule of law? While we may have concerns about cloud computing, have we already been in the cloud for decades? Anyway, so that is the end of this presentation. And I don't know if there are any questions.
Thank you very much, Ian. Mr. Falbo posed a question about whether or not the Law Society possessed an Enigma machine, and sadly we do not. We had one once, it broke. We did not replace it.
Well, there is an Enigma machine in the Signals Museum in Kingston, Ontario, but it's only got 4 wheels. It doesn't have the 5. And it's on loan from CSEC.
So again, anyone, if you have any questions, if you could send them through the chat function, we'll give you a couple of minutes to do that. And if not, then we'll sign off. Ian, I want to thank you once again for your presentation. It's not often that we talk about Enigma machines and sea monsters in the course of a CPD. And thank you for presenting it. I don't see any questions. So everyone, enjoy your weekend. Thank you again, Ian, and we'll be signing off.